And then she says the defendant never assaulted her, and they even spent time together after the police left. That's probably all true. That doesn't mean it didn't occur, though. Review it. All right, D1. Okay, so that's the evidence. Probable cause, challenge or stipulation?
We're going to challenge it, Judge.
You are going to challenge it based upon D1
Yes.
and other factors? Okay, so prosecutor will start with challenge and probable cause on the charges of, there are 3. It is simple assault, and it is terroristic threats. All right, those are the 3 charges. Anyone in particular or all 3, Ms. Bitters?
Judge, my intent was to challenge the simple assault charges. I did not know that the state filed on the terroristic threats. I believe that was placed on a summons.
Yes,
it was.
Okay.
Yes.
I have nothing, no discovery or anything on that terroristic threats charge.
Okay. All right, so on the simple assault charge.
He's only being held on the simple assault with the jail.
Right. Okay, we'll focus there. So it's probable cause is where we're starting, and it's on simple assault. And again, I have the D1, which alleges that she fell and hit her head. She wasn't hit by the defendant, and that she was confused at the time she spoke to the police, that her injuries were not related to an attack by the defendant. So with that, State, you have the floor.
Yes, Your Honor. On November 10th, 2025, officers spoke with the victim, who I'll refer to as AA. AA stated that her boyfriend, defendant Ricky Gilliard, slapped her hard. AA had a noticeable cut on her forehead. AA was treated by medical personnel on scene and informed officers that she recently had a restraining order against defendant, but had dropped it. AA also informed officers the defendant had assaulted her earlier in the day by spitting on her, and charges were filed with police. This is as you said, a simple assault in a domestic violence matter, Your Honor.
Okay, so here, the affidavit of probable cause, I guess, suggests that it was spitting on her was the assault, not getting hit on the head. Even though the officer noticed a cut on her forehead, it appears the spitting is the claim. And there is let me look at the clear to see if there's a 911 call, or who called 911, if any. Let me see how are the police involved again? Let me go back and look.
In Your Honor, if I may, I believe the simple assault charge, there's 2 current simple assault charges, but the one on the complaint warrant is the one for slapping AA, which caused a cut on her forehead. The spitting charge, which is the other current simple assault, that is on a summons. So that is not on the current complaint warrant.
Okay, so the probable cause, is there a probable cause statement on this slapping? Where's that coming
from? Yes,
yeah.
Your Honor, there is. So I have in front of me the complaint warrant sequence number 004730.
Right, 4730. I read that and it says spit on her. The affidavit of probable cause that I have, 4730, says spit on her.
The one I have, Your Honor, says slapping her in the face hard enough to cause a laceration to her head.
Boyfriend who was not listening slapped her hard. Noticeable cut for a call for medical personnel. It's both, actually. They treated her on scene, but she refused to go to hospital. Victim wanted to state that she recently filed a restrainer against Mr. Gilliard, but dropped it, and that he had assaulted her earlier in the day by spitting on her, and the charges were filed with the police. Okay, so that's the earlier one. I got you.
Yes, that's the summons, Your Honor.
Okay. Is there a 911 call? How did the police get involved? Generally, the pleader would tell me whether 911 was called or not, but I don't see it on the pleader. Do you know, do you have an investigation report that tells you how the police got called?
Yeah, so I have an investigation report. We did not send it to Your Honor. If you'd like me to send it right now, I can, but it does state in the beginning, it pretty much says what the affidavit of probable cause says. It just says the police received communications in regard to a call for an unknown disturbance.
Right, so that's a 911. Does it say who the caller was?
No, it does not, Your Honor. It just says that police received a call from police communications in regard to a call for an unknown disturbance at the listed address.
All right, so that could be a neighbor calling or something like that. All right, I don't need it. So any additional arguments based upon our colloquy on probable cause? State first.
Your Honor, just that the D1 submitted by defense today does not take away from the probable cause in the probable cause affidavit that was established, where the victim had stated to police that her boyfriend, the defendant, slapped her hard, and that police had noticed a noticeable cut on her forehead, Your Honor. That's all from the state.
Okay, and Ms. Bitters?
And Judge, we would pretty much have the exact opposite argument. Based on D1, we would suggest that it does take away from the state's probable cause. AA specifically says Mr. Gilliard never assaulted AA, and thereafter they spent the night together. It's my understanding she also refused medical treatment. So it's our position that based on that, the state does not have probable cause for the simple assault charge.
All right. Due to the low standard for probable cause, I'm going to find probable cause. The standard itself is probable cause is a well-grounded suspicion that a crime has been or is being committed. State versus Moore, 181 NJ 40, 2004, and many, many, many other cases. So the law's settled on that. But in this instance, applying those facts, we have a situation where the two have a relationship. They had prior restraining orders, because it indicates that in the affidavit of probable cause, which she dropped. She said she was spit on earlier and filed charges with the police. So in sequence, it looks like there was an early conflict, which could be motive for the later conflict. You know, you already went to the police. Why'd you do that? So the later conflict, which is what the challenge is here, that the defendant slapped her and caused a scratch. Okay, it doesn't seem to be a significant injury. It's not the injury itself. It's whether that was domestic violence. And a slap to the victim is domestic violence if that's what occurred. They are in a relationship, and it's a strike to the face. It's not a strike to the body. When you strike somebody in the face, it's a more vulnerable area. You got your nose, your eyes, your ears, etc. So the location of the strike is concerning. But again, then we have the aftermath where she then submits something that says totally contrary to what she told the police, and says she was dazed and confused at the time she reported to the police based upon hitting her head. And let me read it. It says she had fallen and hit her head. She does not say that in the affidavit of probable cause. She did not require treatment, significant treatment. Seems to be a minor injury, so I can't imagine she was dazed and confused and she fell and hit her head. And then she says the defendant never assaulted her, and they even spent time together after the police left. That's probably all true. That doesn't mean it didn't occur, though. Again, the fact that there was a precipitating event earlier with a spitting incident and a police report better lends itself to the fact that he may have been mad at her and slapped her, and that now she's remorseful that he's charged, facing these charges. And by the way, a restraining order, because it says in there she had a restraining order, dropped it. All lends itself to the cycle of domestic violence, where victims have remorse. They initially call police for protection and imminent assistance, but after the dust settles, they drop everything, and that's what this seems to be in the court's judgment. And so, given the low standard for probable cause, I am finding that that these events are supported by the statements by the victim to the police at the time they occurred, before she had time to reflect and reconsider the consequences of what she's saying. They seem to be more honest statements at the time of the incident. So with that, probable cause found. All right, move on to detention. Back to the state.
Yes, Your Honor. So as to danger, the PSA properly recommends no release. The PSA ranks a 5 for risk of new criminal activity, and the defendant is flagged for an elevated risk of violence. Defendant has 3 current charges. 2 of the charges are domestic violence incidents where defendant assaulted his girlfriend, and the 3rd charge stems from him threatening to kill the investigating police officers and his entire family. Sorry, the police officer and his entire family. Defendant also has 2 pending charges at the time of the offense, 1 for terroristic threats and 1 for throwing bodily fluid on a law enforcement officer. The risk of danger is amplified by defendant's 14 indictable convictions, which include robbery, burglary, receiving stolen property, 2 criminal mischief convictions, 9 convictions related to his possession and distribution of controlled dangerous substances. The risk of danger is echoed by defendant's 9 disorderly person convictions, which include 4 convictions for criminal trespass, unlawful transit conduct, resisting arrest, and 2 more controlled dangerous substance related convictions. Defendant also has 8 prior sentences of incarceration of 14 days or more. Among them are 2 sentences for criminal mischief, 1 sentence for receiving stolen property, 3 sentences for possession with intent to distribute or manufacture heroin or other CDS. These sentences of incarceration, as long as 3 to 5 years apiece, have done nothing to mediate defendant's dangerous criminal conduct. And this is all on top of defendant's juvenile record, which is necessarily excluded from the PSA and includes 3rd-degree theft charge, for which defendant was placed into the juvenile intensive supervision program and was given probation, which he promptly violated. The state would also like to point out the 2 domestic violence restraining orders against him, that although they were dismissed, the underlying conduct for each included assault and terroristic threats. In fact, the victim here, AA, obtained a TRO against defendant just last month for assault, but allowed the TRO to lapse, only to be assaulted again in the current incident. As to obstruction is inherent in domestic violence cases. Domestic violence cases are notoriously susceptible to intimidation or coercion of the victim to ensure that she does not testify, and this undermines the judicial process and perpetuates the cycle of violence. Defendant's risk of obstruction and flight is amplified by his current charges for terroristic threats against police, his pending charge for throwing bodily fluids at police, and his 2 convictions for resisting arrest. Defendant's risk of obstruction and flight is further evidenced by the fact the defendant committed these current offenses while he was already on probation and pretrial monitoring, and the current offenses are obvious violations of his probation and pretrial monitoring. So with that, Judge, the defendant's criminality is continuous and undeterred by arrest, court process, incarceration, or community-based supervision. Thus, the state respectfully requests that the court follow the recommendation of the PSA and hold defendant in detention pretrial, as no amount of monetary bail and or non-monetary conditions can be imposed that will protect the triad of interests at issue here, Your Honor.
Thank you. Defense.
Judge, Mr. Gilliard is 27 years old. He has his GED. He lives locally in Atlantic City with his uncle. He has recently lost both his mom and dad. And because of that, he helps to take care of 2 young brothers, 8 and 10. He does have a prior record, but I would just point out that he has no failures to appear ever, not in the past 2 years and not before that. He also has no prior violent convictions on his record. He is on probation and pretrial monitoring, but he tells me he's compliant with both of them. He's had no positive drug screens. He's taken his prescribed psych meds. He hasn't failed to report, and he's doing everything that probation and pretrial monitoring has asked of him. There's no evidence that he will fail to appear for court, having no prior failures to appear. It's our position that he's not a danger to the community or to this victim in particular. Based on D1, she has said that she's not scared of him. She does not have a restraining order, and they were together even after this incident. There's nothing to suggest that he would obstruct the criminal justice process, and this is, He is before you just on this disorderly persons simple assault. We've already argued probable cause, so it's our position that the state is going to have a hard time meeting their burden in this case with a victim who is saying that this never occurred. So for all those reasons, we are asking the court to release Mr. Gilliard.
Okay, any response from the state if necessary, briefly?
My apologies, I was muted, Your Honor. No, that's all from the state, Your Honor.
All right, great. All right, so this is State versus Ricky Gilliard. It's warrant 2025-0047300102. PSA was run on 11/12/25, so it's current. The face sheet of the PSA instrument, 3 for failure to appear, 5 for new criminal activity, which is high, a flag for violence, and no release recommendation. Face sheet also indicates he's 27 years old. He's currently on probation, G0044881, and he's also currently on pretrial monitoring, level 1 out of Atlantic County. Going through the factors, nature and circumstances, defense charge. It's a low-level charge, so it's not an indictable, but it's domestic violence. And even though it's a DP, we take domestic violence very seriously. We're implored by the legislature to protect victims, to prevent the reoccurrence, and have more serious consequences to the victim, and not ignore low-level charges, and which could be an indicator of ongoing problems and threats to the victims. So here we have a simple assault charge on a warrant. We also have other charges on summonses, but the warrant simple assault is the main charge. And it's alleged that she slapped the victim in the face, but earlier he had spit on her, and as a result, she filed criminal charges, and she had in the past or related to this filed for a restraining order. So she took initiative earlier, and that could have been the motive for what resulted in the slap in the face. In other words, she's taking action adverse to the defendant. He was unhappy about it. She did submit the report D1 that says police were mistaken, that she fell and hit her head. She's not afraid of the defendant. That's probably true. She's probably not afraid of him. Unfortunately, that's something the courts have to deal with in terms of the cycle of domestic violence. Many victims do get injured, and they're not afraid of the person. They get injured again. So we have to reconcile and distill all that. Weight of the evidence, it's going to be a challenging case for the state. She does not want to pursue it. She has indicated that in D1, but there is some evidence. There's an officer's observation of the injury, which could corroborate her initial complaints. And there's statements originally made by the victim. And then if she recants, it becomes an issue of credibility. There's a call to the police. Somebody made it. I don't know if that person would be willing to testify or if that was the victim herself, and her 911 call would be admissible. So that's a potential as well. And lastly is the injuries observed by the officer. There's some physical evidence. So, but it's going to be a challenging case for the state, no doubt. History and characteristics of the defendant, it's unsettling. It's unfortunate too. He's 27. He lives with his uncle. Apparently lost his mom and dad as a caregiver to younger brothers. I admire him for taking care of his brothers, but he's not being a good caregiver by engaging in domestic violence, being on probation, being on pretrial release level 1. He's not a good influence. He's not setting a good example for his brothers. And his criminal history, which I'll get into next, is also not compelling. He is only 27. He has 19 DP convictions going back to trespass, resisting, criminal trespass, unlawful transit, resisting, criminal trespass. So he has a history of resisting. And those are his DPs. His indictable convictions, again, this is only a 27-year-old. Going back to 2017, he is a felony out of Washington, I guess, WA, robbery, criminal mischief, mischief endangering, manufacture and distribution. Now I'm up to 2023. 2023, receiving stolen property. Possession with intent to distribute, 2023. Burglary, 2024. Possession with intent to distribute, 2024, multiple times. So he is, again, taking care of his younger brother. Imagine who they'd look up to. Their big brother, who's in the business of distributing harmful drugs which poison and kill people in the community, all for his income stream, but his income stream is killing many other people or poisoning many other people. So it's not a good history. And most recently, 2024, third degree conviction is probably why he's on 12/2024. So just on the eve of 2025, he has convictions for possession with intent to distribute, third degree here in New Jersey. So he's on a rampage in terms of criminal behavior. His record appearing in court doesn't have any FTAs. That's a good thing. So he shows up when he has to, unless he's coming from jail. Notably in the PSA, he spent multiple stints in jail. He was in jail 2023 for 3 years, 2020 for 5 years, 2020 for 5 years. So he's had a 5 and a 3 basically in jail as a youngster. He's a young adult. He has restraining orders, 2 of them from 2024, 2025. They were dismissed, but it shows that the victim had to reach out to the court for initial protection. Getting into where the rubber meets the road, nature, serious danger of person or the community posed by his release. He's been in jail for a 3 and a 5, and he's undeterred. He is only 27. He's on pretrial release, level 1, and on probation. Again, he's undeterred, assuming that these charges are valid and believable, that he's still engaging in behaviors that offend pretrial release and offend probation and involve a female victim of domestic violence. So I consider it very serious. Nature and risk of obstructing the criminal justice process. He has a history of obstructing. He does show up for court, but he has a history in his criminal rendition that I read earlier of resisting arrest. Those were older, 2017. And so he does have a dated history of resisting. So I would call that a moderate risk, not a serious one. There is the potential for witness intimidation if it hasn't occurred already, because it's a paramour. And the allegations are serious that spit on her and then slapped her, and then she called for the police and then shortly thereafter recanted. So that's always concerning to the court. Finally, there's the instrument itself, which has significant weight on the court. It's a 3-5 with a no release and a flag. So based upon everything I've heard, the D1, it does concern the court that the state's going to have a weak case to prosecute, but everything else, I note that he left the booth. Is he in the booth?
Yes,
He's
Judge.
back. Okay.
He never left the booth, Judge.
Yeah. I note that, that there is D1, but again, I think this is part of the cycle of domestic violence, and that the incident did occur, that the victim does need protection. I think she may have been coerced or is just whatever the mental exercises or gyration people go through after being attacked by their loved one and want to drop charges. I think that's what's at play here. And he's going to be detained. Mindful that he's already on probation. He's already on level 1. He already has pending charges, and his criminality is not abated. I don't know if he's on drugs, because he has a history just in 2024 of distributing, whether he's using and distributing, or distributing to use, or just a distributor. I don't know if he needs help. Ms. Bitters will have to figure that out, and if he's eligible for drug court, because he's someone who's really just selling to use, or other things in his life, if he needs mental health treatment because of the life experiences that he's had, lost his mom and dad, caring for his brothers, if that's a stressor that's causing him to engage in the behavior that he's engaging in, or he just can't control himself. But his criminal history is telling, the current circumstances are telling he's going to be detained. I am finding that the state has established no amount of bail conditions or both. Protect the safety of persons of the community, assures appearance in court. Satisfied the state's met that burden by clear and convincing evidence based upon the PSA, the affidavit of probable cause, his criminal history, etc. And that is the court's ruling. And he has 7 days to appeal. Anything else from the state?
Your Honor, this is
Yes.
Sarah from pretrial. He has a violation and a motion to revoke.
Right. So we'll deal with that afterwards, but just on the decision itself, thanks for reminding me, Karen. Any concerns about the decision or corrections or misstatements of fact or anything that parties want to correct the court on? And then we'll go to the VOM and the motion to revoke.
Not from the state, Your Honor.
Okay.
Excuse me, Judge. It seems like he's left the booth.
All right. It's either low, sometimes he's out of camera view. On the motion to revoke his release, since I've already detained him, I think that's moot. And the VOM, I'm going to find he was non-compliant across the board with pretrial services. He was failing and he was non-compliant with keeping his address up to date. He's non-compliant with requiring not to commit a new offense. He did not report to pretrial services by telephone after being released on 11/1. He didn't seek employment. He didn't undergo the medical, psychological, or psychiatric treatment as required by the court. He failed to contact pretrial services. The recommendation is the defendant is currently subject to pretrial release conditions level 1, absent a motion for revocation. They recommended that it be increased, but there was a motion to revoke. So again, the motion to revoke, I'm going to grant it, but it's moot at this point in time. I'll say the motion to revoke granted on the old charges. So he's going to be revoked on the old charges, but it's effectively moot because I'm detaining him now. All right. So I will change the conditions since he cannot report anymore since he's in jail. So there'll be a termination of pretrial release conditions and monitoring that's appropriate. I'm going to put moot, detained, new charge. And it's ordered that defendant's release conditions and all monitoring is hereby terminated. I'm going to say moot, detained, new charge. All right.
Judge, just so you're aware, the jail advised that he is gone.
Okay. Records to reflect he left the booth. He was frustrated. So, all right. I'm going to put motion to revoke release granted. All right. Anything else?
No, Your Honor, not from the state.
No, thanks, Judge.
Thank you. All right. This matter is concluded. Again, 7 days to appeal.